morning. I'm Richard Bennett, attorney for the appellant. We are here today appealing an order dismissing our request for declaratory judgment with prejudice. The only issue is whether the plaintiff can seek a Chapter 86 declaration of rights and obligations under a statute where the statute itself does not contain a private right of action. This court in the city of Apalachicola found it was error to construe the underlying statute where a declaratory judgment was requested and considered in the city of Apalachicola whether a request for a declaratory judgment properly stated a cause of action.
Was this the first complaint in the file? I mean, the first complaint filed by your client?
Yes, Your Honor.
And a motion to dismiss was granted with prejudice?
Correct, Your Honor.
Was there a request by you or trial counsel to amend? Judge, you may be right about this, but we'd like an opportunity to amend our pleading to see if we can say a little better. Anything like that below?
No, Your Honor. The order was transmitted several weeks after oral argument on the motion to dismiss.
And help us understand that. So you have the hearing, and then some weeks later, here comes the order dismissing the complaint with prejudice. So it's what you would say to us is you didn't have the opportunity, not knowing what was going to be in the order, to ask the court for leave to amend.
That's right, Your Honor. We filed a class action complaint on behalf of other persons within the statute of limitations who had been subjected to the same charges for 4 CT scans from the emergency room where the scans were used to diagnose injuries of car accident, PIP-covered patient. We also filed and served with the complaint comprehensive discovery requests and a motion for class certification. The only order the court entered was by agreement of the parties that the case was a complex action and subject to the complex action rules. We had one hearing after briefing by the parties. The judge requested proposed orders from both parties, which we submitted, and then we received in the mail or served through the ECDS system the order. Which
Even if we agree with you that a declaratory action is not barred, what is the dispute here given that the hospital is not trying to recoup any monies from your client at this point?
Your Honor, the statute that we're asking for our rights and their obligations to be determined requires that a hospital bill patients only a reasonable amount. That's our cause of action, that the billings are not reasonable. And we ask for a jury to be impaneled to determine the issue, the fact issue of reasonableness, and for the judge to determine.
Didn't they write them off?
Pardon?
Didn't they write off the bills in some fashion?
There was supplemental insurance of the plaintiff for Medicare, and they weren't allowed to recover more money under the Medicare rules.
But your
That's
client
correct.
is not still suffering a significant financial loss. Is that correct?
Yes, Your Honor. The complaint alleges that due to the unreasonable charges, the high charges, his $10,000 PIP coverage was prematurely exhausted, and he's subject to other medical providers' bills, ambulance charges, other surgeries, medicines that he would have had money to pay for, but for the charges that were levied against him in this case. The judge.
So what, to follow through with that thought, counsel, what would the trial of a case like this look like? I mean, what would you envision your client's presentation being? I mean, given the fact that it appears undisputed that these bills were written off, I mean, what would this look like in front of a jury?
Well, if the jury would determine whether the charges for these 4 scams were reasonable under the criteria set forth in the statute, which is evidence of their usual and customary charges and payments received, reimbursement levels in the communities from other medical providers and hospitals, federal and state fee schedules, such as the Medicaid fee schedule, which would have allowed $1,000 as full payment for the charges that were levied at $41,000 against our client. If a jury returned a verdict as authorized by Chapter 86, the judge then would be asked whether the hospital violated the law. In that case, we would be entitled, if our class had been certified, to make certain class claims for supplemental relief as may be appropriate.
But this isn't the class action here.
It is class action. I mean, we alleged class relief and we moved for class certification with the complaint when it was served. The reason
And
we
then
didn't,
follow up on, I apologize for interrupting, your point about the premature exhaustion of PIP benefits. I mean, is that not due to the insurer's decision on how much to pay as opposed to how much the hospital is charging? Help me understand that distinction.
all right, well, there were several medical providers involved in this case. And the way the PIP works, whoever files first is entitled to be paid. The hospital delayed for some reason making their claim, so they only ended up getting $5,000 of their $50,000 bill. The insurance has no incentive to contest charges where their limit of payment is $10,000 and the bills are $50,000, and they don't do it. So we're left with no option but to assert claims that the law was violated by the existence of what we feel are unreasonable charges. And the complaint set forth the criteria, and we had facts alleged on what their payments, usual payments are, what other hospitals charge in the area of the Medicare fee schedules, and we had charts showing that we had a prima facie case to allege the unreasonableness of the charges. The judge committed error, in our opinion, when he found that we could not bring a declaratory judgment action because the statute didn't provide a private cause of action. This is contrary to this court's ruling in the city of Apalachicola. And the cases that the judge relied on don't support his holding. Florida physicians.
Assume, counsel, we agree with you on that. Where do you go from there? Because behind that, I think they would say there were other reasons that this should have gone away, separate and apart from the private cause of action. If you could give us a benefit of what your arguments are in that regard.
Well, that there are common law causes of action that we could assert, and we will assert after we have discovery to support our claims.
And maybe that wasn't a great question. Assume Franklin is the law, and it's the law of the first DCA, and the court may have been in error for not having followed Franklin, for having followed a fifth DCA case that may have been receded from. But separate and apart from that is, I understand their argument is, well, we still win because we have other defenses to this claim that would entitle us to a dismissal with prejudice. What would you say to us as to why that shouldn't happen?
Well, if the case was remanded and we were allowed to proceed with discovery in the case, we may very well amend our complaint to add counts such as were alleged in the Herrera case, the federal case, the only case that's directly on point that construes this very statute and makes the same claims of unreasonableness, and the defense attacked for the same reasons that the defendant here attacked. That we didn't have any right to challenge the reasonableness of the charges because the statute provides for the insurer to contest charges, not the patients. And Herrera, they
In that
alleged.
case, those claims were alleged, right? So that
That's
the duplicate
correct.
claims were alleged, and they're not alleged here. All we have is a deck action. So, is that a requirement for us to determine whether a dispute exists, whether there's a common law claim that could be pled or that has been pled?
Well, that's what the Adventist case exactly said that the court relied on. The court relied on Florida physicians, Adventist, and Adventist, the language in Adventist was even if the statute did not contain a private cause of action, and even if the complaint did not allege other causes of action, it still is a judicial issue because it goes to whether a real, actual dispute exists between the parties. In Herrera, they pled unjust enrichment, deceptive trade practices, breach of implied covenant of good faith. And the court allowed those claims to go forward and found that the statute at issue did not prohibit the plaintiff from contesting the reasonableness of the charges. We could do the very same thing. We didn't do it on the initial complaint because we didn't have discovery to support those claims, and we didn't feel comfortable making claims without evidentiary support. So we elected to go with the statutory declaratory judgment statute because it provides that to state a cause of action, you have to be claimed to be interested in a declaration of rights and obligations under the statute. And that's exactly what we want to do for the class. Did the hospital breach the obligation to only charge reasonable amounts in the billings? We're not and our complaint asks for a declaration that it was unlawful for them to charge these amounts for these 4 CT scans. That's our claim. It didn't go further than that. It says everyone who goes to this hospital and is treated after an automobile accident has a right to know whether these 4 charges were reasonable or they violated the law. So that's the sole issue here that we have raised. And we brought it for a class because Chapter 86 provides that all persons who are interested or whose rights will be affected by the declaration can be joined as parties to the case. We believe these charges are so egregious, so outrageous, that we need to deter the hospital from charging that. And this is the way we want to proceed, bring this issue before the court and get a ruling through.
You're in your rebuttal time, just.
Okay, one other point. In the Rabaya case from the Second Circuit, the court found that the Sunshine Act didn't contain a private cause of action, but found it was common for complainants to seek relief under Chapter 86 while alleging a claim under a statute that did not contain a private cause of action. The Supreme Court in Kendrick versus Everhart allowed an paternity action where the statute provided that only a woman could bring a paternity action under the statute and that no other causes of action would be allowed a declaratory judgment action for the father to contest. So clearly, it's a separate test for declaratory action standards for stating the cause of action, as opposed to whether you're suing under the statute.
May it please the court, Jonathan Williams here on behalf of the Appalachian Crestview Hospital Corporation. Because Mr. MacNeil was unable to identify any right of his that depended upon the issue whether the hospital's charges were reasonable within the meaning of the PIP statute, the circuit court was correct to understand that he was being asked to render an advisory opinion in a non-justiciable controversy, and therefore the circuit court was correct to dismiss the case. And solely by relying on the grounds articulated in the dismissal order, this court can affirm the dismissal here. Now, I'd like to start by talking about...
I've got several questions. Let me start with the first. We have a complaint, a motion to dismiss, and then a couple weeks later, an order comes in the mail, comes in through the email, dismissing with prejudice the claim. And then we look at our Franklin case that arguably is at odds with the case the trial court relied on. So let me ask you first, why not send this back to give the plaintiff an opportunity to replete this claim? And/or if Franklin prohibits precisely what the trial judge did, would they not have a claim that could be adequately pleaded under Chapter 86? That's two questions.
It is, so I'll give two answers. As to the issue about amendment, you've heard from plaintiff's counsel that he didn't request it to amend. There was no request for reconsideration of the decision to dismiss with prejudice, and most importantly, the dismissal with prejudice as opposed to with leave to amend was never identified as an error in the briefs in this court. So the issue has been waived 3 times.
Well,
so it's inappropriate to reverse
I want to understand that. I understand the argument, but I want to understand what you're saying to attribute to the plaintiff waiver when there's no ruling at the hearing. So we have the first complaint. We have an order that comes in the mail by email saying, not only am I dismissing this, but I'm dismissing it with prejudice. So how would you anticipate a plaintiff's attorney to be prescient enough to ask for leave to amend when they didn't even know what the court was going to do? So how could that be waived? I'm having trouble understanding that.
Well, the primary way in which it could be waived is if it's not raised as error on appeal. And it hasn't been raised as error on appeal, and therefore it's waived. So it's waived in that sense.
Well, they've asked us to send it back, so I don't understand.
Well, they've asked to send it back because they say the order was incorrect in its resolution of the disability issue. They haven't asked for it, so they want you to send it back and allow the case to go forward on the theory that they pleaded. What they haven't said is we should have been allowed leave to amend. So in that sense, they haven't made that argument.
Well, let's set that aside. Let's say Franklin controls. First DCA controls. And Franklin says this is a viable claim. The whole basis of the trial court's order dismissing with prejudice this complaint was something not in the first DCA. A fifth DCA case has arguably been receded from by another fifth DCA case. So why shouldn't we send it back to the trial?
Well, in the event that the court were to determine that there was error in the order, yes, I agree that the case could proceed. However, there wasn't error in the order, and because both of the conditions that you articulated do not hold in this case. First of all, City of Apalachicola is a case that turned entirely on statutory language of the Florida Governmental Conflict Resolution Procedure. Specifically, what the court did was it looked at the language of that act, which allowed parties to pursue any otherwise available legal right. And in the very next sentence, the court said that a declaratory judgment action is an otherwise available legal right. And then the court looked to determine whether the ordinary elements of declaratory judgment action were pleaded and determined their otherwise. And therefore, the court reversed. City of Apalachicola does not articulate a per se rule that it is never relevant in any case to assess accessibility whether there is a private cause of action in the complaint. And that's because there are two problems that would occur if that were the rule, which was not articulated in the City of Apalachicola. One, it would read the justiciability requirements out of the case law. Two, it would have generated a conflict with the 5th DCA's decision in Florida Physicians Union, which at that point was a decision that had come more than 10 years before. So the notion that this court sub silentio reads out the justiciability requirement in City of Apalachicola and then creates conflict in a way that would not be necessary to decide the case. I don't think City of Apalachicola gets them.
Well, I think their retort to that would be there's a later 5th DCA case that in essence receded from the earlier 5th DCA case, recognizing that there was this common law right to advance a claim under Chapter 86. So, I mean, how do you deal with that? I mean, we have a 5th DCA case after the 5th DCA case you're relying on, the trial court relied on, saying there could be a claim under Chapter 86.
Well, I don't think that's the correct reading of the Adventist Health opinion. Because Adventist Health first analyzes the Florida Physicians case and says that the Florida Physician case holds that because that statute did not create an implied private cause of action, all that was being sought in that case, where the only argument was, as here, that there's a private cause of action and that's what gives me a right that's enforceable. What it understood Florida Physicians to say was that under those circumstances, there's no justiciable controversy. And then it distinguished Florida Physicians on two bases. First, it determined that the statute before it did create an implied private cause of action, and therefore there was a distinction. And second, it addressed an argument that had never been raised in Florida Physicians, and also that was never raised in the court below here, which was that regardless whether there's an implied private cause of action, there's some other cause of action that would allow me to enforce this statutory requirement. And that argument was never made in this case. So that's not receiving from Florida Physicians. What it is distinguishing Florida Physicians on two bases, and the holding remains in place. And of course, the holding would have to remain in place because it was a subsequent panel opinion, which couldn't overrule the prior panel opinion. So I want to focus on the difference between the argument that is made on appeal here and the argument that was made in the circuit court. The argument in the circuit court, and I would point the court to page 296 of the record, which is part of the hearing before the circuit court. Judge Catchell specifically asked plaintiff's counsel to clarify what exactly it was that he was arguing. And plaintiff's counsel, and he said, are you arguing that there's an implied private cause of action to enforce the PIP statute? And plaintiff's counsel said, yes, Your Honor. And he proceeded to argue why there was an implied private cause of action under the PIP statute. And applying well-settled principles of statutory interpretation, the circuit court rejected that argument that there was an implied private cause of action. And because that was the only basis of any right, judicially enforceable right, on which Mr. MacNeil relied, there was no right that was being articulated to the court that could support a justiciable controversy.
The problem I have with that argument is you're talking about argument by plaintiff's counsel. We're here on a complaint. We're here on a complaint as pleaded. We aren't here on argument. Are you saying by virtue of that argument being advanced in opposition to your motion to dismiss, that's all it can ever be, or all it ever will be, and he is somehow judicially stopped by virtue of having made that argument? I'm having difficulty appreciating how you're saying that this argument advanced to Judge Catchell somehow morphs into an addendum to the complaint that's not otherwise there. But help me understand that.
Well, it's not an addendum to the complaint, Your Honor. The complaint sought a declaration that the hospital had made charges that were unreasonable within the meaning of the PIP statute. That's all it said. It didn't say there are these other causes of action. It sought a declaratory judgment, as appellant's counsel confirmed. And the hospital moved to dismiss, saying you can't get a declaratory judgment in this context absent a private cause of action. And there is no private cause of action. Therefore, the case should be dismissed. And the argument on appeal, the argument in response, which was the only argument that was preserved for appeal, was actually, yes, I can get a declaratory judgment because there is an implied private cause of action. So I'm not arguing estoppel. What I'm arguing is that he has to preserve his arguments below, and he can't simply abandon the argument he made below, try to make a new argument here, and then get the court to adopt this new argument that was never considered below by the circuit court as a basis for error, because by definition the court can't err as to an argument that was never presented.
But our evaluation's denoted, is it not, on a motion to dismiss with prejudice? Aren't we looking at this complaint to see if in fact there's a cause of action? Isn't that the real issue in front of us?
The real issue in front of you, yes, it's de novo review, but it's only de novo review as to arguments that were actually advanced below. De novo review does not mean the circuit court doesn't matter anymore. Were that the case, there would never be any reason for any plaintiff trying to resist a motion to dismiss to make any argument at all. He could simply accept the dismissal, take a little more time, develop his theories on appeal, and get the court, in the first instance, to allow him to make brand new arguments on appeal. That's what the waiver principles of appellate review do. It requires an argument to be asserted in the circuit court below. The only circumstance in which that's not the case, an example of a circumstance, there may be other circumstances, this isn't one. An example of a circumstance where that would be not be the case is, for example, if there were an argument about subject matter jurisdiction. Arguments like that are subject to waiver. But there's an obligation on a party resisting a motion to dismiss to articulate the reasons that the claim should not be dismissed. He articulated only one reason, and it was that he had a right that was judicially enforceable by virtue of the implied private cause of action. Judge Ketchel rejected that argument. Mr. MacNeil abandoned that argument on appeal. He's now trying to make a different argument on appeal, and that's what the waiver rules prevent. It prevents a circuit court from being reversed on a basis that was not advanced to the circuit court.
Let me ask you a question. Assuming, for purposes of my question, we get over that hurdle, one of the questions that I ask is whether there's no longer a dispute because the hospital wrote off the balance, and so his client is not out any money. And the response is, well, there's still the exhaustion of PIP benefits that makes this a dispute that's in controversy. If you could respond to that.
Certainly. So assuming that there is a justiciable controversy, which of course we don't agree with, yes, that's one of the hospital's alternative arguments, that because in fact all of the charges were waived, because Mr. MacNeil never paid one penny, and because the insurance only reimbursed approximately $5,400, that there's no real controversy. And here's why. The complaint list is among the reasonable charges, the charges that are more reasonable than the hospitals. The $11,000, I believe it's approximately $11,500 national average for these procedures. Well, that's more than twice as much as this PIP coverage actually paid. So if you're suing for unreasonable charges, and one of your markers of a reasonable charge is twice what your insurer paid, then by definition, the claim fails on its own force. And that's absolutely something that the court can consider on appeal, just because it's analogous when a court considers the actual terms of the contract in a contract action. So here, there's a dispute about what the price term is. He alleges that the price term is more than $40,000. The hospital introduced into the record the actual price term, that is what the hospital actually collected.
But aren't we bound by the four corners of this complaint? I mean, I hear you. That may be a very valid argument on a motion for summary judgment, but we are restricted to the complaint and any attachments to the complaint, unless, and there is an exception to that, and not relevant here, of judicial notice, which has to be consented to by the other side, but I don't see that in the record. So what you're verbalizing is not in this pleading.
It's correct that it's not in the pleading, but it's incorrect that judicial notice is the only circumstance under which documents outside of the complaint can be considered. When a document is a central feature of a complaint, as in a breach of contract action, the court can actually consider the contract even if it's not attached to the complaint. We've cited authority to that effect in our briefing.
I
And
saw
here-
that as a second DCA case that I disagree with. That case would say that you can go outside the four corners of the complaint and the attachments. So that's the position that you would hold, that this second DCA case would allow you to introduce, independently of the complaint, evidence to take away the cause of action.
That's right, Your Honor, we believe that case was correctly decided. If however you disagree, then you disagree, and well, there we are. But the key point here is that, as the circuit court correctly recognized, when the plaintiff can identify no judicially enforceable right that depends upon a factual or legal issue to be decided by declaration, then there's no justiciable controversy. And that's exactly what Judge Ketchel held. That decision is supported by the second DCA's opinion. It is consistent with the justiciability requirements and declaratory judgment actions that have been set forth by the Florida Supreme Court and this court in cases including Outford v. Bessner, and the court consented to affirm on the basis that was articulated by the circuit court in this case. Thank you.
Thank you.
Your Honor, we're appealing the order of dismissal with prejudice and the reasons that the court gave for dismissing the case. Fortunately, we have a transcript of the hearing, and our argument was obviously that we stated a cause of action under Chapter 86 because that's the only thing we made. The judge, although the defense presented evidence of a second bill, the court did not consider that and announced at the hearing it was improper for them to be submitting documents on a motion to dismiss, and he was bound by the four corners of the complaint.
But do you dispute that the bill has been written off at this point? Regardless of whether the trial court considered that, what is your position? Because I thought I heard earlier that really the controversy is about exhaustion of PIP benefits now as opposed to your client being burdened in a financial way.
Your Honor, our complaint never alleged that we owed any money to the hospital. What our complaint alleged was defendants' unreasonable and unlawful charges contributed to a premature exhaustion of plaintiff's $10,000 PIP coverage. As a result, plaintiff remains liable for additional medical services which were rendered by third-party providers related to the underlying motor vehicle accident that would have otherwise been fully or partially covered by plaintiff's PIP benefits, as well as any and all resulting financial consequences of those additional expenses. Such additional expenses and consequences include, but are not limited to, ambulance services, third-party radiology charges, surgical procedures, prescription medicines, interest payments, adverse credit impact, and insurability issues. So that's the claim that we're making. And the judge did not consider this evidence, which would be more appropriate on summary judgment, and he dismissed the case for the reasons stated in the order, not based on the argument of counsel. Thank you.
Thank you, Mr. Bennett. Thank you both for your argument.